South Africa's Constitutional Court has handed down a landmark ruling that could reshape how we view parenting, gender and work. It has struck down part of the Basic Conditions of Employment Act and the UIF Act for unfairly discriminating against fathers, adoptive parents and those using surrogates. Now, from today, as I understand it, any two parents can share 4 months of parental leave while 6 weeks remain reserved for birth mothers. Parliament now has 2 years to amend the law, but employers must comply immediately. Well, let's try and make some sense of this and how important this development is. John Botha is with me, Joint Chief Executive Officer of Global Business Solutions. He is a labour law expert. John, a very warm welcome. In plain English then, what exactly changes for employers and I guess for parents starting today?
Yes, thank you, Jeremy and listeners. The big issue here is a move away from a gender bias and a stereotypical view that only childbearing parents, i.e. women, had the 4 months maternity leave. What now has happened is they've opened up the 4 months not only to non-childbearing parents, but also to adoptive parents and commissioning surrogate parents. So effectively that 4 months and 10-day period is now available to any of the parents to share as they wish, as long as it doesn't exceed that total period.
John, you've called this interim relief. What exactly does that mean in practice for HR departments and line managers moving forward?
Well, Jeremy, what it means is with immediate effect, organizations have to review their maternity leave policies, their parental leave policies, that, for example, only gave men 10 days parental leave or adoptive parents 10 weeks. That extension to 4 months and 10 days is immediate, although Department of Employment and Labour have been given 2 years, as you indicated, to amend the BCEA and the UIF Act. But that does not exonerate current employers from immediately amending and realigning their policies. So if a non-childbearing parent, like you or I, went to our employers now, if you had an employer, Jeremy, and said that you've decided to take on the childcare responsibilities, your wife is going to continue working, that employer would have to agree immediately. Failing that, it would be an unfair discrimination matter, and of course, there's some significant consequences attached to that.
So let's talk about that. If a company fails to update those policies that you've mentioned, it would expose them to discrimination claims. How would that manifest?
That would be a very, very, very serious risk for any organization. The Employment Equity Act, I know we spoke some time ago about the amendments. To get an employment equity certificate, Jeremy, you need to not only meet some ministerial targets, but you also must not be found guilty of any form of unfair discrimination in the 12 months preceding that certificate application. So if there was a company that thought, well, we're just going to sit it out and wing it, we're not going to extend this particular, right, then they're going to lose significant opportunities for tenders. They're facing labor court orders and, of course, reputational damage. The big question, Jeremy, if I may, is many organizations already are paying childbearing parents all or part of their 4 months. So a woman that's pregnant in companies like Woolworths, for example, would be getting payment. Now they're going to have to extend that payment to the non-childbearing parent, the adoptive parent, or the commissioning surrogate parent. And I think that's what is quite a big concern for business.
What it effectively does is that it's going to be a more onerous administrative and payroll change, is what you're suggesting.
All three of those included potential financial consequences. So we're just hoping it doesn't have the opposite effect where companies now might say, okay, if you're currently employed, we'll give this benefit to everyone, child and non-childbearing parents, etc. But new employees will only get the UIF option. Now, one is hoping that these types of extensions and judgments don't prejudice people unnecessarily.
Do you think that smaller businesses are more vulnerable?
I think they are, Jeremy, even if it's not primarily financially, operationally. An example would be that someone adopts 2 children in a year. I mean, potentially they're out for 8 months. or someone has more than one partner and they father more than one child in a year. So a small business is going to feel the effects of this much more significantly.
John, let's talk about the Unemployment Insurance Fund. Business Day is reporting, and I quote, enormous financial burdens on the UIF triggered by this Constitutional Court decision. And Parliament has now been tasked with reviewing the law to cushion the impact. How is this going to impact the UIF and its ability to pay, given that the fund itself is under a fair degree of strain? And I think I'm being nice there.
You're being exceptionally nice. There have been significant calls, as you're probably implying, for UIF to be put under administration.
Indeed.
Just from a functional point of view. But certainly in the judgment was interesting that the Department of Labour argued that the fund's under already financial pressures, etc. And the court, the Constitutional Court, said, listen, these are constitutional rights, so you've got two options. If it's going to cost you too much, well, then go and impose a higher UIF levy on employers. Alternatively, if you can't do that, or it's going to have an adverse impact, then reduce the UIF payments that people would be entitled to with the current budget. So we're going to have to see how that pans out, Jeremy, but one can only hope it's not going to increase the cost of employment.
And just a final one, what impact on morale and I guess as well staff retention? This is a family-friendly policy. Surely there is the potential of this becoming a competitive advantage.
Absolutely. It's a massive competitive advantage in the war for talent, given all the other labor laws where thousands and thousands of organizations are vying for talent, and especially in the context of employment equity. So, if you can use this and see it as an opportunity, Jeremy, it can only underpin and boost your diversity, inclusion, and belonging culture. So I think from that point of view, and I've always been of the view that this was unfair discrimination in any case. But we'll have to just see how it pans out in terms of practical application.
John Botha, thank you very much indeed. Joint Chief Executive Officer of Global Business Solutions.